I want to watch just a couple of minutes of this video. This is from Audit the Audit. Audit the Audit's a huge channel. Everybody probably already knows who Audit the Audit is. If you're not, though, I'm subscribed to his channel. I watch his channel. It does a little cop sucking, but I still like his channel. I want to show you guys this because this breaks down how important it is for you to invoke your Fifth Amendment right to remain silent.
And the right and wrong searches, and is brought to us by ABC News 4's channel. Be sure to check out the description below and give them the credit that they deserve. On August 20th, 2020, Corporal Robert Barano of the Somerville Police Department initiated a traffic stop on 42-year-old grandfather Timmy Miles after he drove away from his Somerville, South Carolina residence. Prior to the stop, Charleston police officers had intercepted a FedEx package containing marijuana that was sent to Mr. Miles' home, but addressed to an individual who did not live there, and, according to Mr. Miles, was not known to him or his family. As part of a narcotics surveillance operation, officers from the Somerville PD delivered the package to Mr. Miles' front porch, and at least 2 officers watched the package from a wooded area behind Mr. Miles' home. At one point, the officers lost sight of the package, and when Mr. Miles drove away, Corporal Barano pulled him over on the mistaken belief that he had picked up the package and put it in his vehicle. Corporal Barano approached the vehicle, and the encounter that followed was captured on body camera.
You just I know what you picked up. I know what you picked up over there, okay?
What I picked up?
Yeah. Come on. Get out of the car.
No, I ain't getting out the car till y'all tell me what's going on.
We're about to tell you what's going on. Come on out.
No, bro. What's going on? Let me record this.
Okay.
Y'all got y'all. What y'all got y'all camera on?
We're recording right now, so come on
What's
out.
going on?
We got the camera on.
Yeah, come on out.
Tell you, all right?
Come on out.
Oh no, don't grab me. Don't grab me. Don't grab me.
Well, we're telling you, giving you lawful order. If you don't get out, you're about to get ripped out of the car.
Well, go ahead.
So what's amazing to me is that this entire thing is over marijuana. It's just so unbelievable to me that this is still happening in our country and that we still are allowing this to happen in our country. The guy's accused of having marijuana shipped to him. Let's say he's guilty. Let's say he said use a fake name. Let's say that happened. Okay. Now what? You got him. You got the bag. You confiscated it. That's it. Let him go. Let him go. That's it right there. If he was a physical or violent threat, he wouldn't be getting marijuana in the mail. So what are we talking about here? But look at the response that these jackboot thug pigs are doing.
No.
We got the camera on.
Yeah, come on out.
Tell you, all right?
Come on out.
Oh no, don't grab me. Don't grab me. Don't grab me.
Well, we're telling you, giving you lawful order. If you don't get out, you're about to get ripped out of the car.
Well, go ahead.
So don't.
I got a back problem. Don't rip me out.
I'm not trying to do that. So come on out. Come on out. We'll explain it to you.
We're gonna tell you, dude. Come on, step out of the car.
Let me go.
No, I'm not letting you go.
Bro, let me go.
This is your last chance, man.
No.
Get the f out.
Oh, look out.
Hands behind your back.
Why you punch me in my face? I don't know what's going on.
Did you hear that? That was horrible.
Hands behind your back.
Why you punch me in my face? I don't know what's going on.
Yeah, pull him up.
If you got your camera on, punch me in my face.
We got a camera, bro.
Somebody punch me in my face.
Can you pause it right there?
Oh, Johnny, what's going on?
Let me pull you up on screen here, Aaron. Go ahead. What are you saying?
Did you hear him say, you got your camera on? You got your camera on?
Right.
Too many people have a misconception that that's going to do a damn bit of good. And here's 2 reasons why. I made a public records request for body cam footage in Toledo, Ohio. It took 19 months to get. 19. And that wasn't even proper. It wasn't even complete. A situation happened in April of this year, I believe. Yeah, April of this year, where an officer's body cam magically isn't uploaded. It was on and recording. You can see the green light solid, a red light flashing, which means it's recording. But there's no footage because maybe the battery was low or the docking error or some kind of server problem. We can't trust their footage. Now, this man here, a dash cam, front and rear facing dash camera, 360 views for his car, something like that, would have picked up at least the audio of it if it's just a front and rear facing. Right. But the police can shut theirs off with impunity like they did in my case. Right. And there's 3 different reasons why this cop gave him, and I can't wait for Thursday for me to be able to talk about it all.
I want to get into that, but I want to center real quick on what you just brought up. if people don't know about Aaron Collins' Great Lake Audits, what he's specifically very good at and has been doing for years is doing freedom of information requests and demand for body cam footage. He's been doing it for years, way before I ever knew him. And so he's telling you right now, how many months does it take you to get the footage?
Okay, so one of them I have is 19 months. Documents from my arrest, which we have trial tomorrow. It's been 17 months since my arrest. I still don't have that completed. They still haven't given me my body cam footage. They still haven't given me the personnel files for these officers. There's so much, and there's 2 different things within the state that require it to be treated as discovery, but yet they're just scoffing at it. So state law says it, as well as rules of criminal procedure for Ohio says it. Learn your rules of criminal procedure, rules of evidence, like that stuff. If you know that, you have a great understanding of what you can and can't do when you make your records request for the stuff they're trying to keep from you.
Well, the important part that he said is, and I qualified him by explaining this is what he does. It took him 19 months on one. On the other one, he still hasn't got the footage yet. And it's the same thing for me going right. I'm in court in Las Vegas right now, and they have not given me all the cam footage. They have not given me the personnel records. And for the lawyers who watch my videos, let me tell you now, if I don't get that stuff, I'm going to sue federally. I'm going to sue everybody involved.
What's going on?
When Mr. Miles refuses to exit the vehicle without an explanation as to why he was stopped, Corporal Barano grabs him around the neck, pulls him from his vehicle, and strikes him several times in the face. We will explore Corporal Barano's use of force later in this episode, but first, it is necessary to discuss the legality of Mr. Miles's conduct in refusing to exit the vehicle. As we have mentioned previously here on ATA, courts have generally concluded that officers are not constitutionally required to inform citizens about the reasons they have been detained. And although Section 17-13...
So that is twisted and morbid. Listen to what he says again here. This is the whole thing. There's no reason in a free United States of America why cops should get to grab you and then not tell you why you're being grabbed.
Required to inform citizens about the generally concluded that officers are nickel. As we have mentioned previously here on ATA, courts have generally concluded that officers are not constitutionally required to inform citizens about the reasons they have been detained. And although Section 17-13-50 of the South Carolina Code makes it illegal under state law for an officer to, quote, refuse to answer a question relative to the reason for the arrest posed by a person who has been arrested, this statute does not apply to Terry stops. Additionally, officers typically have...
Did you hear what he just said? I don't know Audit the Audit. I've been kind of critical about his channel about doing the cop sucking, but I think he's just trying to report the straight facts. But listen to what's exempt.
17-50 of the South Carolina Code makes it illegal under state law for an officer to, quote, refuse to answer a question relative to the reason for the arrest.
So it's a crime to not answer a question about the arrest in South Carolina.
Posed by a person who has been...
What's that, Aaron?
That's beautiful that's a law. The cops have to tell you if you ask. Yeah, that's the only thing I've ever heard that.
But guess what? The number one interaction starts with police. It's a Terry stop is the number one interaction we all watch on video. And listen to what the rules are in South Carolina.
Arrested, this statute does not apply to Terry stops. Additionally, officers typically have the discretion to require individuals to exit vehicles during traffic stops, and for this reason, an order to step out of a vehicle is typically considered lawful. While South Carolina's hindering statute, which can be found in Section 16-5-50 of the South Carolina Code, is limited to interference with arrests, under Section 16-1 of the Somerville Code of Ordinances, it is unlawful, quote, for any person to refuse to obey a lawful order of any officer of the police department for the town engaged in the discharge of official duties. However, if he was charged with violating this ordinance, Mr. Miles could attempt to defend himself by arguing that the order to exit the vehicle was not lawful because the underlying traffic stop was not based on reasonable suspicion. Although it is difficult to determine whether Corporal Barano had the reasonable suspicion necessary to detain Mr. Miles without knowing the specific details of what the surveillance officers saw and what they communicated to Corporal Barano, given the fact that the package was still on Mr. Miles's front porch, he would have a legitimate argument that the traffic stop was not supported by reasonable suspicion, and that he accordingly could not be convicted of disobeying a lawful order for refusing.
Look at these guys. I mean, take a look.
And that he accordingly could not be
take a look.
Convicted.
Well, also, look at what camera angle we have. At any point in time, did it show this man getting his ass whooped?
No, it didn't.
But all these other guys got their body cams on, and that's the media only putting out what they want you to put out. And that's why I do public records requests, so I get it all, not just what they want me to have.
Of disobeying a law.
But look how they're all dressed. Masks on, dressed like G.I. Joe. I mean, gunfights do happen in America, but they don't happen they just don't happen like, it's just, they look ridiculous.
Full order for refusing to exit the vehicle.
So he's crying about being punched in the face. I didn't see that.
Yeah, I sure do. I sure do. My face is hurt, man. Somebody punch me. I'm a good citizen. Punch me.
I thought I was going to 300, but we got the package still there.
Yeah, we have to make sure that we don't have anything.
Yeah. And conveniently, they show other angles from other officers, but not the whooping he took.
Did you hear what this guy said? If it's not there, then we don't have anything. I think they were talking about the package.
Yeah, the box.
We looked in the Chrysler 300, but it's not there. So the evidence they have against the guy is no longer there. They have no evidence. And they beat him up and choked him. They punched him in the face. He's crying about being punched in the face because he's a good citizen.
Going to 300, but we got the package still there.
Yeah, we have to make sure that we don't have anything.
They lost sight of the box, and this car left. We stopped it. He didn't want to get out. We had to extract him. It's not there. Yeah. Yep.
Someone sit on the house?
We got snipers. We got
Talk about state of custody foobar.
I mean, and talk about insane. You're surrounding a guy's house with snipers because there's you get weed in the mail? Like
the naturally growing plant. Come on.
Lookers. Still on the porch.
Resisting. Oh, mother. Man, y'all get
It's on the porch still.
He's mad because he got charged with resisting, and they punched him in the face and choked him.
After Mr. Miles was physically removed from the vehicle, the officers realized that the package was not inside it, and later determined that the package was still on the porch. Despite this, they continue to detain Mr. Miles and keep him in handcuffs.
Torture cuffs.
There you go. Somebody punched me in my face.
So he's saying, let me go, I'm not going anywhere, because he's in so much pain from the torture cuffs. He just wants to be let out. He said he's not going to run off. But then, as he's being a drug trafficker, he didn't bring the drugs to traffic.
But that for real, though. Somebody hit me hard, too.
Somebody's still crying. I mean, I'm not much of a crier, but I get it. I understand why he's so upset.
Somebody going to jail for real behind it.
No. See, and that is where we are super unfortunate, is that nobody's going to be going to jail for this.
No one except for him.
No one except for him. Nobody's going to go to jail for this. The cops are not going to get in any trouble at all whatsoever. And as long as that system of complete and utter non-accountability, the cops that I'm suing bunches of cops, and in Ironton, I may have to refile my lawsuit again. It doesn't matter. I'm going to appeal, maybe not appeal. Anyway, the point is, the police don't get in trouble. The people who I'm suing will never, they'll get told, oh, you lost in court, or oh, we beat that guy in court, but nothing will happen to them. There'll be absolutely no repercussions for their actions. The only time that ever happens is if they're criminally charged and then convicted. And as you guys see, the judges, when cops murder people, they give them a hug before they sentence them to 2 years in prison with time already served.
Anybody get it? You want to search it?
What?
This car?
Yeah. Continue research. I mean, we'll get a dog because right now he's going to say no. He didn't pick up the package. So let's get a dog, make sure there's probable cause. We search the car. I already popped the trunk for safety.
Come on, man. I want everybody car. Everybody car. Hey, you brave.
He popped the trunk for safety.
That's a
you real.
Yeah, of course it is.
Not search incident to an arrest.
There's no rule of law, dude. This is not rule of law. I talk about rule of law. I talk about rule of law all the time, and this is not rule of law, Aaron.
No, what tears me about this one is they admit they had no PC. He never touched the package. So there's no PC to even talk to him about it, much less pull him over, whoop his ass, and illegally enter his vehicle. They opened his trunk looking for the drugs. not for safety. He doesn't have a swarm of bees hiding in there. He doesn't have a whole bunch of people with machine guns lying in there. They wanted to find the box because they couldn't see it when they did a plain view search of his interior of his car. Safety my ass.
Afraid to be punching on, choking people, man. You wrong. You had no business choking and pulling on me like that. I would have complied only if you'd have let me know what the was going on. I come out my yard, everybody swarming me and punching me and throwing me on the ground. That's ruthless. That's thuggish. And y'all call us mother.
Mr. Miles confronts Corporal Barano about his use of force in choking and punching him, and states that he would have complied with the order to exit the vehicle if the officers would have just told him what was going on. In the 2016 case of Armstrong versus Village of Pinehurst, the Fourth Circuit Court of Appeals, which has jurisdiction over South Carolina, determined that, quote, non-compliance with lawful orders justifies some use of force, but the level of justified force varies based on the risks posed by the resistance.
Okay, so let me explain something here. The states can make any kind of holding statutes. They can do anything they want. It can go all the way up to the state Supreme Court. The law, the policy of the land is Graham versus Connor, 1989, which creates objective reasonableness, the objectively reasonableness standard. If a police officer believes in his mind that you could be violent against him, he can use the amount of objectively reasonable force that the reasonable officer deems necessary for the situation. Police are allowed to keep order, and for officer safety, Terry 1968 plus Graham 1989, if you have officer safety plus objective reasonableness, that means that the police can literally punch your head into the concrete, smash your brains, and kill you. And it could be considered objectively reasonable, considering what they may believe in their mind that you could have done or are willing to do during this interaction with them. So this is why I do love Audit the Audit, because he shows these different laws and things. But the supreme policy of the land created by the unelected Supreme Court is that they can use objectively reasonable force.
Applying this precedent, the U.S. District Court for the Eastern District of Virginia, which is also in the Fourth Circuit, held in the 2022 case of Nazario versus Gutierrez that, quote, when police lawfully order a driver to exit his vehicle and the driver refuses, police may use reasonable force to remove the driver.
And the reasonableness force standard has been dictated to us in the 1989 case of Graham versus Connor. Reasonable force is up to the reasonable officer on the scene.
In reaching this decision, the court recognized that, quote, a key determination in the reasonableness inquiry is whether the resistance is active or passive, and noted that, quote, verbally refusing to exit a vehicle constituted purely passive resistance. Interestingly, we explored the interaction involved in the Nazario case in a previous episode of ATA, and I've included a link to this episode in the description down below if you're interested in learning more.
It's absolutely ridiculous. He won his case and they gave him $3,000.
In the present situation, even if a court concluded that Corporal Barano had the legal authority to forcibly remove Mr. Miles from the vehicle, given the entirely passive nature of his resistance, Mr. Miles has a legitimate claim that the type of force employed was excessive and constitutionally unreasonable. In the 2008 case of Cleary versus Green, the U.S. District Court in Maryland, which is also in the Fourth Circuit, held that an officer did not use excessive force in physically removing an individual from a vehicle when she was spun around and slammed against the vehicle several times. However, the court justified this decision by arguing that the officer ceased the use of force once the individual was in handcuffs, and that he did not punch or slap her, implying that such a use of force would be excessive. Additionally,
we can slam you around all we want until you're handcuffed. Then we got to stop. This is my handcuff. My God.
In the 2020 case of Wilson versus Painter, the U.S. District Court for the Eastern District of Virginia denied qualified immunity to an officer who delivered a single closed-handed strike to the face of an individual who failed to comply with 4 orders to exit his vehicle. And in a 2021 case by the same name, the Fourth Circuit Court of Appeals affirmed the denial. In support of its decision, the District Court noted that no more than 15 seconds elapsed between the first command to exit the vehicle and the punch, that the officer blocked the driver from exiting the vehicle by situating himself between the open door of the vehicle and the driver, and that although the driver did not immediately comply with the officer's orders, he did not undertake any threatening or evasive movements. Now, while Corporal Barano...
Yeah, go ahead.
Does that sound like a very similar situation where an officer puts himself in a position to affect someone else's behavior or movements so they could get violent.
Well, I think the state
Connor
case is this
Grub.
in Ohio?
I don't know. I missed the where it was at, but it sounds awful familiar to like Takaya Young, Connor Grubb, who put himself in a position to where she would have to act a certain way when threat of force is used so they could get the results they want.
I believe
That's why
we'd have to know the different states and if they're going to apply both ways. I'm not sure, but
even if it's
about 35.
Go ahead.
Even if it's a federal case, not the same circuit, there's the persuasive authority argument that can be made to transfer the outer ruling to this. But I hope they use a standard. I really do.
Well, but the thing is, Aaron, is if it goes to court, I would argue Graham versus Connor that I used reasonable force based on my objective reasonableness of the situation. You know,
and she wasn't handcuffed yet, so they get to do it.
Yeah, and he wasn't in handcuffs just yet. I mean, he is suing. I don't know if it's a federal civil rights lawsuit, then the federal policy is going to be Graham versus Connor. So
5 seconds before employing force while Corporal Barano waited about 35 seconds before employing force and did not appear to block Mr. Miles.
He's got the glove on, ready to punch him in the face. Look at the padding over the knuckles. See it?
Those are biker's gloves, isn't it?
Exit from the vehicle. He used more force than Officer Painter did, as he grabbed Mr. Miles by the throat and punched him twice instead of once. And given the fact that Mr. Miles did not resist physically or even make any
he's a black thug gangster wearing a Washington Redskins hat and driving a 300 Chrysler. So he must be a gangbanger. And they had weed being delivered. He must be a Crip or a Blood. And that's what they're going to tell the jury, who's full of Karens and Kevins.
threatening or evasive movements, he would have a strong argument that Corporal Barano used constitutionally excessive force against him.
Please, then I'm paying my tax if you would.
But you told me you wanted to
But can I get some medical ambulance?
Yes.
I want to get my child pregnant because I got cards in my face. You know that's wrong. Come on, man. Come on. No.
You refuse to get out of the car.
Refuse to get out of the car.
And then he's going to sit over there and justify to the guy after he got punched twice and choked.
I went like, oh, this man grabbed me first. I said, why are you grabbing me? I got a right for my rights now. Come on now. You behind me. I did the right thing. I stopped. And then you ordered me to get out the car for what? This man choking me.
907 North Palmetto.
Died over choking.
The good news is that you're alive and you're kicking.
The good news is you're alive and kicking.
He's giving him good news. Good news.
You hadn't been to choking me, bro. For choking me, you going down. You ain't had to put your hand on my neck. It ain't that serious. For whatever you looking for, bro.
This is what you're waiting for a canine.
Where's
Waiting for a canine. So that's the 2018 case of Rodriguez versus United States. That's illegal. Okay, they can prolong a stop if they have reasonable articulable. So I guess it wouldn't be constitutionally illegal because their singular articulable fact is that bag of marijuana that was mailed to him.
Well,
What's that, Aaron?
but he didn't pick it up. He doesn't have it with him, and they know he doesn't have it with them. So that's got to go. There's nothing. This is just like you said. They're unlawfully extending a traffic stop to try to cover their ass for whooping his ass and screwing up royally by not being able to see a box is still on a porch.
Aaron got it. I was a little incorrect in my analyses, and he was spot on just now. Exactly correct, Aaron.
I do not want a search on my car. I do not allow a search on my No. I do not conduct a search on my car.
Yeah, they called him.
They're extending the stop of an already illegal stop. He's going to win his lawsuit.
We thought there was a package in there.
And they're on body cam admitting that they're Keystone moron cops.
We did. It was supposed to be a controlled delivery.
Gotcha. Yeah, if we can get that trunk closed for him.
We can get that trunk closed for him.
All right, we're done violating his Fourth Amendment. Let's close it so we can continue to violate his Fourth Amendment a different way. Scratch.
Yeah.
Nope, no hits. Oh,
No.
man.
All right. I appreciate it. Thank you.
Did they notify you about sending emails to the traffic stop?
Negative, sir.
I feel bad for the guy who went through this, but I love seeing them step on their own.
Can we get one for blackmail, approximately 30, 35, complaining of head trauma? Nobody notified me, so they're coming now.
Y'all say the EMS were coming on.
They're coming. I confirmed that they're coming now.
We're going to search this. We can take anything else to find it. Secure his phone.
What's that?
So now they're searching his vehicle. Is he being arrested? Is this a search incident to an arrest, or is this a search on the fact that the dog didn't hit on a damn thing and now they're just violating his Fourth Amendment a different way? They're finding every way to violate this man's Fourth Amendment outside of going into his rectum.
So I could, do a search warrant. Didn't admit to using marijuana.
No, I did.
Hey, you know what? Just do the instant to arrest. We'll hand it over rather than tow it.
This is stuff back behind here with this stuff, but you got a corner cut and it smells like weed in there, so.
Yeah, he has a couple baggies in the front as well. Yeah, I'll get photos of him.
The drug dog that didn't hit on the dope.
They just wanted to arrest him, so they're just arresting him without any probable cause, no nothing.
We're going to charge him and release the car to mom.
Even though Mr. Miles explicitly and
We're going to charge him and release the car to mom.
adamantly denied consent to search his vehicle, and the canine unit sniffed the vehicle and did not alert. After Mr. Miles admits to using marijuana for his back problems, the officers thoroughly search his vehicle, including the contents of notebooks, folders, and other containers.
Oh my.
All containers require warrants. Good job.
Listen.
See, look, they found another way to violate his Fourth.
Listen, you guys have got to listen to me. It's on the trifold. I have a Fifth Amendment card coming out. It's still not done. I'm so sorry. You shut the front door. They had nothing. When he said that they smoked marijuana, that gave the cops reasonable articulable suspicion to search your car. I have it on a freaking trifold that I give away for free. Aaron, did you know that? Do you know I give the thing I sell to make money? I give it away for, do you know that? I give it to you for nothing. I gave away at least 20, 25 today for free. I want you to buy it. Please buy it. Don't think that's a segue to, hey, let's just everybody get one for free because I need to make a living. Aaron knows how hard it is to make a living being an activist.
Oh my God.
But listen, shut the front door. Stop your dang talking. My God.
And do not find Mr. Made consent.
Okay. Listen again, please. And this is why you have the trifold in your car and why you follow the principle of the Fifth all the way to the dungeon if it need be, and then you continue till your lawyer and your family's there to get you out.
Sent to search his vehicle, and the canine unit sniffed the vehicle and did not alert. After Mr. Miles admits to using marijuana for his back problems, the officers thoroughly search his vehicle, including the contents of notebooks, folders, and other containers, and do not find any illegal substances. As we have discussed in previous episodes of ATA, the Supreme Court held in the 1983 case of United States versus Place that a canine sniff does not constitute a quote-unquote search for Fourth Amendment purposes. And in the 2005 case of Illinois versus Caballes, the court determined that, quote, a dog sniff conducted during a lawful traffic stop that reveals no information other than the location of a substance that no individual has any right to possess does not violate the Fourth Amendment. However, the Supreme Court clarified in the 2015 case of Rodriguez versus the United States that officers cannot extend a traffic stop beyond the time needed to handle the matter for which the stop was made to conduct a dog sniff without independent, reasonable, articulable suspicion of additional criminal activity. This situation is more complex than the typical traffic stop.
I was wrong. I said 2018 Rodriguez. I apologize. It was 2015. I misspoke there. He said exactly what I just said and what Aaron confirmed.
As there are serious questions about the legality of the underlying stop and Mr. Miles' apparent arrest. And the issue was further complicated by the fact that the officers failed to request emergency medical services until after the sniff was completed, although they seemed to be waiting for EMS to arrive before taking Mr. Miles into custody when the canine unit arrived. Still, Mr. Miles would potentially have an argument that his roadside seizure was unlawfully extended to allow for the canine to sniff his vehicle. Additionally, while the legal issues surrounding the dog sniff are murky, it is far more likely that the court would determine that the officer's extensive search of Mr. Miles's vehicle violated the Fourth Amendment. Although officers are generally required to obtain a warrant before searching a vehicle, courts have recognized several exceptions to this rule under which warrantless vehicle searches are considered constitutionally reasonable. For instance, as the Supreme Court explained in the 1996 case of Pennsylvania versus LeBron, quote, if a car is readily mobile and probable cause exists to believe it contains contraband, the Fourth Amendment permits police to search.
Okay, so read that with me. If a car is readily mobile and probable cause exists to believe. This is not the Fourth Amendment. The Fourth Amendment is unreasonable searches and seizures. If you're creating a probable cause to believe standard, then you're always going to be guilty because you can always believe that there's contraband in someone's car.
Search the vehicle. Although the Fourth Circuit Court of Appeals held in the 2002 case of U.S. versus Sheets that the odor of marijuana gives officers probable cause to search a vehicle, there is no precedent suggesting that a driver's admission to general marijuana use allows officers to search their vehicle. And in this situation, it is likely that a court would conclude that the officers did not have probable cause to search Mr. Miles's vehicle based on his admission to using marijuana, absent any evidence tying that use to the vehicle, particularly given the fact that a canine unit had sniffed the vehicle and failed to detect any illegal substances. Other exceptions to the warrant requirement include inventory searches when a vehicle is being impounded.
I mean, that's going way out on a limb trying to decide what judges are going to do because you just have no idea.
And searches incident to arrest, which, as the Supreme Court explained in the 2011 case of Davis versus the United States, is limited to situations where, now quoting, the arrestee is within reaching distance of the vehicle during the search, or if the police have reason to believe that the vehicle contains evidence relevant to the crime of arrest. A court would almost certainly conclude that these exceptions did not apply because the vehicle was not being impounded, Mr. Miles was nowhere near the vehicle, and the officers did not appear to have probable cause that any evidence was in the vehicle, having already determined that the package was still on the porch.
That medicine bottle right there also.
The arresting offense was resisting. Had nothing to do with anything with drugs or anything like that. The arresting offense is resisting. So the supporting evidence, drugs, guns, whatever, are not part of the resisting charge. And they know the drugs never left the house because they're on the porch. So I would argue the entirety of that was gone. All they could come on.
Right. The package was still on the porch.
That medicine bottle right there also belongs to him. I didn't do the trunk yet.
I think the city wants to leave it alone.
Okay.
Once EMS arrived, Mr. Miles was taken to the hospital by ambulance, and after receiving treatment, he was officially arrested. According to a lawsuit Mr. Miles filed regarding the encounter, he was originally charged with possession with intent to distribute marijuana under South Carolina state law and disobeying a lawful order of police.
But there was no marijuana, though. How do you possession with intent to distribute if you don't have any of the marijuana on you and you don't? I'm confused.
That's disgusting.
In violation of Section 16-1 of the Somerville Code of Ordinances. But both charges were later dismissed. However, publicly available court records only list the drug charge, which was dismissed on January 19, 2021. Less than 2 weeks after the encounter, Corporal Barano was terminated from the Somerville Police Department due to his actions during the stop. According to a so-called separation due to misconduct form completed by department representatives, quote, Corporal Barano can be seen on video striking the defendant in the face twice. And, now quoting again, another detective can be seen grabbing Corporal Barano's arm in what appears to be an attempt to prevent him from delivering more fist strikes to the man's face. The form...
Oh, Aaron, did you see that? I didn't
No. Because it's that selective enforcement or selective release of body cam. They don't want you to see the guy whooping his ass and someone else having to intervene.
Another detective can be seen grabbing Corporal Barano's arm in what appears to be an attempt to prevent him from delivering more fist strikes to the man's face. You know, I'd like to see that. How come we can't all see that?
Concluded that, quote, there was no apparent imminent threat or danger to Corporal Barano or to the other officers on scene, and that, now quoting again, Corporal Barano utilizing a closed fist and striking the subject in the face was not justifiable, was not objectively reasonable, and was a violation of department policy and state law. On Friday, October 29, 2021, former Officer Barano was arrested and charged with third-degree assault and battery against Mr. Miles, and on September 1st, 2022, Judge Ryan Templeton found him guilty after a bench trial, sentencing him to time served. On August 19th, 2022, Mr. Miles filed lawsuits stemming from his encounter with Corporal
Bam, right there. And that is the McDonald's Pepsi challenge difference right there. It's, are you going to follow up and are you going to file a lawsuit? Are you going to sue? And I can't file everybody's lawsuit. I don't write people's lawsuits. I'm busy doing a lot of stuff. But you have to sue these jackboot thug pigs.